Hi, my name is Mark Bryant. I'm the founder and the president of the Bryant Law Center located in Paducah, Kentucky and Louisville, Kentucky. We're a small band of lawyers, 8 people who practice law in personal injury and mass torts. And we have had the good fortune of being very, very successful and helping thousands of people who have come to us over the last 30 years that the firm's been in existence. The one question that I often get from people that try to represent themselves is, what does an adjuster mean when they ask me these questions? And the answer I'm getting ready to give you, but I want you to know that insurance company adjuster is not there to be your friend, despite what they tell you on television. In the very beginning, after you've had an accident, you may get a call from the insurance company and their adjuster asking you to explain about the wreck. Do not talk to them if you're going to get a lawyer or if you've had any thoughts about getting a lawyer. But I'm telling you, insurance claims adjusters are not your friend. An insurance claim adjuster will employ a variety of negotiating tactics to get you to settle your claim for as little as possible. Let's look at 4 statements the claims adjuster might make in conversations with you to learn what the adjuster really means and how you should respond if you decide you want to represent yourself. And some people do. I'd advise against it, but nonetheless, some people do. So number 1, when the adjuster says, "I'd like to take your statement," what he really means is, I want you to commit to one version of what happened right now so that I can use it against you if you try to change your story later. Adjusters are paid to investigate claims and gather facts. The linchpin of their investigation is your statement. And believe me when I tell you, the adjuster will try to get you on the phone or in person as soon as possible after the accident. Why, you might ask? Because symptoms often get worse in the 24 to 48 hours after an accident. They want to catch you while you are still in shock or before your symptoms really set in. The adjuster will use your statement to commit to you a version of what happened. Next, they're going to use it to question your credibility if you correct an innocent mistake or add an overlooked detail. Next, they're going to look for interpretations that reduce your claim's value. And next, they're going to disprove injuries that you have suffered which worsen after the statement is given. So you really need to be cautious dealing with these people because really they're not doing this to help you. They're doing this to decrease the amount of money that the insurance company pays out, which ultimately is going to end up giving the adjuster a bonus at some point in time for saving the insurance company money. So be careful. Now, what's the adjuster mean when the adjuster says, "Please sign this medical authorization form"? What he really means is, please sign this form so I can gain access to your entire medical history, going back to the womb, and perhaps find something I can use against you. I've got story after story, I can tell you this, and it is just repulsive what they try to do through the adjusters and then the lawyers for the insurance companies that represent them. And they're all over the country. I mean, it's those lawyers will do anything that they can to help the insurance company out because they're being paid by the insurance company. So be very careful dealing with adjusters. Adjusters often ask you to sign a medical authorization. This gives the adjuster permission to obtain copies of your medical records. The problem is that most of these insurance companies' authorizations are broadly drafted and give adjusters the ability to delve into a claimant's complete medical and psychological history, as opposed to just obtaining records related to treatment for the accident itself. This allows the insurance company to pry into pre-existing conditions and medical or psychological issues that may be unrelated to your claim. Most claimants who do not have a lawyer will sign these medical releases because they think if they cooperate with the adjuster, this will increase their chances of getting a prompt and fair settlement, and that is just total malarkey. And what about this? When they ask, why do you need an attorney? I'll work with you on a claim. And this happens all the time. They do not want you to get a lawyer. They especially don't want you to get a lawyer that knows what they're doing. And believe me, they know what lawyers know what they're doing. But what the adjuster really means with that question is, please don't call an attorney. When an attorney gets involved, it becomes much harder for me to push you into a fast, cheap settlement. And when the adjuster deals an unrepresented claimant, the adjuster has the upper hand because he knows how the system works and he has been trained in negotiation. Once a personal injury attorney gets involved, the adjuster loses his advantage. As a result, to discourage you from contacting an attorney, the adjuster might say, your claim won't be any more valuable just because you get an attorney. This is false. The price tag of a claim almost always goes up when an attorney gets involved. Or, why do you need a lawyer if I'm looking out for your best interest? And that is simply not true. The adjuster is actually seeking the opposite. He wants to pay you as little as you will accept. Or, if you get a lawyer, we'll have to hire one as well to take your deposition. Well, that's true. But if the case proceeds that far, a deposition is nothing to fear. You're merely giving your statement in person with your attorney at your side. And don't think they don't already have a lawyer working on this. They have lawyers working all the time, and they're just waiting for your case to come across their desk. So you need a lawyer too. And then another question is, if you hire a lawyer, it will slow down the claims process. That's true, but it also will likely result in a much better outcome for you. And lastly, when the adjuster says, if you don't accept this amount now, we will withdraw all offers. What he really means is, please take this low offer so I can close your file and get it off my desk and work on some other poor person that has had an automobile accident and wear them out too. This is often a bluff. If your case is worth $20,000 a day, it will likely still be worth $20,000 tomorrow and next week and next month. It is not a bluff, and the claims adjuster withdraws the offer. Consider the withdrawal an invitation to file a lawsuit. But don't file that lawsuit on yourself unless you got a law degree. And then once again, don't do that because the old adage is a lawyer who represents himself is a fool for a client. So let's recap this. Decline to give a statement to an insurance adjuster. Pick up the phone and call a lawyer that does this for a living. Require limiting language on any medical authorization form you sign. Next, understand that the adjuster really does not want you to retain an attorney. Next, do not fear the adjuster's threat to withdraw all offers. Compare the adjuster's last offer to your claims value and then decide whether to accept it. And always remember too, that there's a statute of limitations on every car wreck case. If you try to represent yourself and it goes past the statute of limitations, they're not going to give you a dime because they don't have to. If you need help evaluating your claims value, call us to discuss it. There's never a charge to consult with us, whether you hire us or not. And if you do hire us, you don't pay anything until the case is over and the money comes out of what we recover from your win against the insurance company.